Anirudh, we can start.
Yes, ma'am. Good morning to one and all. My name is Anirudh Ramanathan, and on behalf of the Students' Council at Government Law College, Mumbai, I welcome you all to the second technical session of the three-day International Conference on World Constitution, Our New Horizon on Human Rights. Former US President Ronald Reagan once said, and I quote, "Ours was the first revolution in history of mankind that truly reversed the course of government, and with three little words, we the people. We the people tell the government what to do, it doesn't tell us. We the people are the driver, the government is the car, and we decide where it should go and by what route and how fast." Almost all of the world's constitutions are documents in which governments tell people what their privileges are. Our constitution is a document in which we the people tell the government what it is allowed to do. We the people are free, I unquote. I would like to welcome our resource person for this session, Dr. Bernard Sihnaya, a professor of law at University of Nairobi School of Law. We are honored by your presence, Professor. I would also like to welcome our chairperson for this session, Dr. Ushoshi Guha, advocate, High Court of Bombay at Nagpur, an IPR specialist and an educator. We are grateful for your presence, ma'am. Our principal, Dr. Asmita Vaidya, has also graced today's occasion. We are grateful to have you here with us, ma'am. We also have with us our senior professors and other faculty members. This three-day international conference is being conducted under the leitmotif of Azadi 75, translated as Freedom 75, and is one of 75 such programs on constitutional law being conducted by Government Law College, Mumbai, celebrating 75 years of Indian independence. We will commence this technical session with the keynote address of our resource person for today, Professor Sihnaya, followed by the presentations by the four paper presenters, and concluding with the chairperson's address. I would now like to take this opportunity to introduce our resource person for this technical session, Dr. Bernard Sihnaya. Dr. Sihnaya is a public interest advocate, mentor, and professor of constitutional law and intellectual property rights at the University of Nairobi School of Law. Professor Sihnaya did his LLB and diploma in law from the University of Nairobi before completing his LLM from the University of Warwick and his doctorate from Stanford Law School, where he did his doctoral research on copyright and cultural creativity in Kenya within the transnational political economy. Professor Sihnaya has also contributed immensely to the Pan-African jurisprudence with over 60 peer-reviewed articles and several authored books under his belt. Professor Sihnaya has also been appointed as a legal advisor to the government of Kenya and has also chaired several committees in drafting legislation, bylaws, rules, and regulations. Professor Sihnaya is also a poet who has written several poems on identity and identity politics, on promoting innovation, creativity, and intellectual property, and on promoting leadership and constitutional government. We are extremely honored by your presence, sir. I now request our resource person, Professor Bernard Sihnaya, to kindly deliver the keynote address.
Good morning, participants. Thank you so much for your very great and introduction. I'm really humbled. It's quite humbling. And I'm also even more humbled to be in this session where we are addressing a very important question on the issue of world constitutions with a focus on the challenge ahead. And of course, the general theme is about world constitutions in terms of implementation of human rights norms and standards. But my focus is on what I see as the challenges ahead. And this is divided into three broad areas. And one is the question of the conceptual and problematic of a world constitution, as well as the question of human rights. The second broad issue is the structural, cultural issues, as well as the trends that have been going on, probably after the First World War, although others could trace it to a much earlier timeline. The third and final issue is about the questions of implementation, questions of enforcement, and hence what I see as the strengths and weaknesses in the existing or extant approach towards a world constitution, because there is evidence that there are certain components which can be regarded as moving towards a world constitution, and particularly to address the question of human rights. So first is the question of the conceptual issues. And these key conceptual questions are related to what is a constitution, what's a constitution, what is their role and purpose at national, subnational, regional, and global or international levels. Can a constitution achieve its purposes in a multi-jurisdictional framework, transnational framework, the same way it could achieve at a subnational or national framework? Those are some of the questions relating to issues of sovereignty, issues of implementation and enforcement, which have engaged so many scholars over time. And whether you call the constitution a charter, or you call it a pact, or whatever it is that we want to call it. Those have engaged so many scholars, and I think this is one of the reasons why scholars like Professor Hans Kelsen and others, especially from a positivist, analytical positivism, argued that international law is not law, it's politics, because of the challenges of implementation and enforcement. But I must observe quickly that Hans Kelsen was writing at an earlier date, before even the UN system got, and the other international systems got underway in terms of implementation. So that comment is not necessarily accurate today as it may have been during Hans Kelsen's time. And what are some of the enforcement mechanisms or institutional frameworks that could support the idea of a world constitution? Suppose we say that one is evolving, or suppose we were to say that one is necessary as soon as possible. How do we define the people who are normally regarded as being at the core of any constitutional project? Are the people with rights, duties, or obligations, with liberties? Are these people at national level, subnational level, regional level, or global level? And are these rights going to be uniform across the board? I'm seeing some literature suggesting that, well, we could just have some of the issues which are fundamental, like right to life and limb, one category, there are certain fundamental liberties like freedom of expression, access to information, and certain basic processes. But then there could be quite a number of problems at national, at international level. Then, of course, there are related questions about how we would have to conceptualize or reconceptualize this question of rights. Do we still have the 3-generation rights which were mentioned yesterday, or are they now 4? And how do we deal with this? Are they still good civil and political rights which were largely developed using Western constitutional and jurisprudential frameworks, and which, of course, other Africa, Asia, and Latin America also were fundamentally Western. What do we say about economic and social rights? And how, so far, do these feature in constitutional texts, constitutional trends, and practice, especially in developing countries and continents, Asia, Latin America, Africa? How have these been? Are they being given the emphasis they deserve in terms of text and rhetoric? And how could that be globalized if we were to do that? Because I'm speaking like this because, for example, American scholars and American politicians and statesmen have been quoted since yesterday and even today, whether you're talking about President Reagan, President Biden, etc. And you will see that the American historical trajectory and trends have been that economic rights are not necessarily part of the colonial text. They provided that there is due process. The state does not, as a constitutional requirement, have positive rights in this regard. I'm aware that also that democratic governments tend to be more sensitive to economic rights and as welfare, but Republicans tend to think that you are going to overburden government, and that probably that is an issue that, as long as there is due process, even issues like right to health should be left to the market, etc. So those are some of the tensions that we have to deal with in terms of various trends in various continents and regions. And third, of course, is the question of communitarian, group, and related rights at the level of family, clan, and other associational rights, which are group-oriented. Again, here, we have always had a big challenge here in many of our developing continents, because like in Africa, Africa had made a contribution to this by helping develop the African Charter on Human and People's Rights, the Banjul Charter of 1981. But while Africa conceptually helped develop that as a constitutional jurisprudential question, it's not true that in most of African countries we are sensitive to these rights anyway. I'm also aware that in Asia and Latin America, and especially India, there's a very strong reference to group rights, so that we don't overemphasize the individual rights are important, yes, but we don't overemphasize them the way Western constitutionalism and Western jurisprudence has done in the past. So that these are some of the, and of course the last one is about the fourth generation. And if you accept that there's a fourth generation, which is being debated quite a lot, and the Constitution of Kenya 2010 clearly acknowledges, without saying they are fourth generation, that there are issues of minority rights, marginal rights, which really do not necessarily belong to the other three typologies. If you accept that, then what is the content of that fourth generation right? Would you include LGBTQI, lesbian, gay, bisexual, transsexual, and queer, and intersex? May I say that under the Kenya Constitution, there's quite a lot of struggle and some judges tend to say that now this is something that we must take very seriously, and also one or two other countries in Africa. But others, like in Uganda, the political terrain and other countries, they've been saying, no, well, these are Western, and that we must not deal with. You're aware that America under Clinton and America under Barack Obama tended to also say that these are issues that we must take very, very seriously, as not just an American issue, but also in terms of their foreign policy. So these are some of the issues that we have to deal with now and into the future. So, and then again, how do we achieve conceptual and policy or institutional harmony, as well as unity in diversity within a world constitution, if we have so many of these cultural differences? Some are major, some are issues of nuances rather than sometimes are cases of distinction without difference, but some are really major, and many communities hold very seriously to them, very close to them, and would not give them. The questions of indivisibility of rights, the issues of if rights are regarded as indivisible, rights are regarded as eternal, rights are inviolable. That has been part of the rhetoric of rights. While not demeaning that, I will go to the second set of issues, which is basically the question of structural, cultural, and trends. The challenges regarding structure, culture and trends in the world. Well, can constitutions and human rights be treated as universal, or are they culturally relativistic? Or is it a combination of both? Well, that's a debate that has not been resolved, and I don't expect it to be resolved in my lifetime. But you will see that when take the universalists who would move towards a world constitution, I know they have made a fundamental contribution to our global processes. Global in a positive sense of teasing out what is common among us, because globalization has also been abused, trying to make one suit fit all of us, even when that's not. But they've made a major contribution, the universities. They developed the UN Charter with basic standards in terms of governance, in terms of norms, rights, issues of peace, security, development, which are really important to us, all of us in the world, irrespective of where we are. They developed the Universal Declaration of Human Rights, which has now become a global standard on assessing human rights in our sub-national, national, and regional constitutions or charters. Really as part of especially customary international law, but almost with a textual or with almost with a treaty impact. Then, of course, they've also developed other norms which are now governing us in terms of environment and natural resources, like the Stockholm Declaration, moving from Stockholm Declaration on the environment all the way through the Charter on Nature, all the way to the Rio Declaration, and all the instruments which really remind us of the need to conserve and sustainably utilize the environment and natural resources on the basis of mutual benefit, etc., etc. Yeah. So they've developed that. They've developed so many important principles which now govern all of us in terms of trade, international intellectual property, which I work on, technology transfer and innovation. And we now agree, for instance, on how to protect and promote IP and innovation, even in the context of HIV, AIDS, COVID, and other problems that ravage the world. That there are certain basic standards that while we respect the rights of innovators, we also need to provide access. These things have been developed by the World Constitution of World Rights advocates. And they have also developed areas such as human rights, and which I've mentioned, and criminal justice, the Hague system, the Rome Statute, the International Court of Justice, the International Criminal Court. These are really important. They're playing a role in our world. Of course, they've also developed standards on education, which I also work on, education, etc., etc. So there is quite a lot of work that has been done. And even at regional level, they have developed charters on human rights and on governance in Asia, Latin America, Europe, the Americas, of course, and Africa, including the African Charter on Human and People's Rights, which I mentioned. So there is a lot of development that has gone on that could form the basis of a world constitution. But I think we need to be told that, well, how well then would it be different from a UN or an amended UN Charter? How would it be different from these other instruments? Much as I know that those are not constitutions in the strict sense. So those are some of the issues, and that, of course, there are also issues like our regional nature and sub-regional nature. Like in Africa, we have East African Community, COMESA, etc., etc. And I know that in Asia and Latin America, they also have some sub-regional processes towards a world constitution or towards better governance and human rights. So these are, there's quite a lot of development in that, but we will have to confront again structural cultural challenges, which include the following in terms of constitutional democracy and constitution making and implementation. Some of our countries, sub-regions or regions, have focused on presidential vis-a-vis parliamentary constitutions, like India largely being parliamentary constitutional framework and has made a lot of contribution in this regard. America being largely presidential. And then there are issues of centralized versus devolved constitutional frameworks, with America standing out as one of the most devolved constitutional frameworks, and in Africa, Nigeria probably. But then there are also some which are very centralized and a unitary system. And those are important constitutional cultures and constitutional traditions, customs, and usages that have to be addressed, and not a very superficial, not just in an academic context, but also the practical policy aspects with participation from the people. There are Republican versus a monarchical constitution. Of course, I'm aware that the monarchical constitutions are really declining, and especially like in Africa, probably we've just had 3, which are, if not pure types. Then there are issues, among others, of flexible versus rigid constitutions. Rigid, here talking about what can be amended by the legislative bodies, what must go to referendum, and what are the relevant processes in amendment or in overhauling a constitution. And I think this is, I'm reminded of a very serious debate that has been going on in Kenya for about 2 or so years now, which is about how do you apply the Indian and the doctrines of which have come from India, from Turkey, from Germany, and other countries, such as the basic structure doctrine. How do you apply the doctrine of eternity clauses? How do you apply the doctrine of unamendability of constitutional texts? And these are not easy issues because, well, it also depends on the kind of control text and control structure and control history that a country has observed over the years. And these are not necessarily universal, although I've seen some academics, including Professor Rosnai and others, suggesting that this is now universal practice on the so-called basic structure doctrine. And what is basic structure, for instance, of a constitution? And is there a difference between basic structure as an expression in the English language, which anything has a structure anyway, and is there basic structure doctrine as a specific constitutional doctrine and human rights doctrine that can be said to be universal in character and practice? And I say no, there is no. What is the basic structure of the Indian Constitution? What's the basic structure of the Kenyan Constitution? What's the basic structure of the South African Constitution, which was very progressive at its time in 1996? The Ugandan Constitution, which was very progressive in 1995 when it was passed, but then has increasingly been amended. And is there a consensus among scholars, consensus among judges and the people on what they regard as the basic structure? And what does it matter, therefore, that if India has talked about certain principles of state policy and certain issues of basic structure, and it's a parliamentary system where amendment is likely anticipated to be in parliament, if at all, is there a difference between Kenya, where Articles 255 to 257 say that these can be amended by parliament, but these must go to referendum? And there is a difference, textual reference, matters of historical practice reference, difference, which also must be respected, because as they say, I think this was JFK, John F. Fitzgerald, who said that if you make peaceful change impossible, you make violent change inevitable. And that's why the doctrine of basic structure doctrine must be looked at textually, structurally, culturally, and in terms of practice over the years. I think the last aspect of, and I believe that I'm still within the timeline, the last aspect of this then is that what I said to be implementation and enforcement strengths and weaknesses. So we have had the UN Charter, we have had UDHR, which were intended to be universal, global, or world constitutions or charters. So we have had issues of concept, agreeing on the various concepts. What are the fundamental human rights? Or what do we call them? Natural rights. There's a difference. Natural rights, human rights, fundamental rights, constitutional rights, legal statutory rights. Even here, we don't have a clear agreement. And then what are some of the institutions that ought to implement them? Is the UN, which is going to be the parliament equivalent of our national institutions under the control. The parliament, the law-making body, the executive, the law implementing body, and then lastly, the judiciary or the law interpreting body. Well, in global terms, some people have said that the General Assembly, UN General Assembly is the legislature, and the Security Council is the executive, but you know the limits of that kind of language. And the International Court of Justice then is the judiciary, among others. You know that there's a limit to that kind of language, because General Assembly does not legislate on all issues that affect us, nor should it. I mean, do we want to lose our sub-national autonomy? These are the consequences in favor of some global uniformity. Has the Security Council as executive been effective even in its more narrow mandate of peace and global security? Because it doesn't necessarily also deal with everything. It only deals with those issues which are going to be a threat to peace and security. And even there have been challenges. And that's why many African countries, Asia and Latin America, are saying, where are we on the table in the issue of permanent membership to the Security Council, and therefore permanent members of the, those are some of the issues that we have to confront. And largely legislature, we know, will we have a court, or do we just strengthen the ICJ or the ICC and implementation enforcement mechanisms of their decisions? There have been issues about even their jurisdiction in the first instance. There have been issues about implementation and enforcement of their decisions. So these are things we must look at, and the similar questions arise at regional and sub-regional level, with merits and demerits of us moving towards a world constitution and a world human rights charter. For the African Union and relevant instruments, the EU, we know EU is having some of its greatest challenges, especially in the Brexit or post-Brexit era. The quest for identity politics after the collapse of the Berlin Wall, if you agree, it collapsed. And there's those ideological challenges of East-West communism, capitalism. It has given rise to even a greater sense of identity at very basic level. The ASEAN issues, the issues in Mercosur, in South America, among others. The North Americans also have their own issues. The US, Mexico, Canada, they have also their certain issues. But I think these have been building blocks towards what one would call loosely a world constitution, a world government. And then there are sub-regional issues, and I'm more familiar with the African ones, such as East African Community, Common Market for Eastern and Southern Africa, Intergovernmental Authority on Development, Southern African SADC, South African Development Community, among others, and ECOWAS, Economic Commission for West African states, among others. And these are also very, very important, but we also know that they are facing certain challenges that would undermine their moving towards a global government. And here, again, as I go towards the end, is that the questions of the bad old neocolonial problems, post-coloniality, and the question of need to retain Afro-African identity, what I would call the Afro-Kenyan, Afro-Ugandan, South African identity, the Asian identity, and the Latin American identity. Those are some of the challenges. And here by neocolonialism and postcolonialism, I don't just mean hacking back or being still controlled economically, culturally, and politically by the former colonial power, but by any other external force, whether it's another country or it's a global body. These are issues in which people are very sensitive. The whole discourse on decoloniality, decolonization, which I read not just as it's not just a racist issue. It's not just that one race subjugated another race, or for me, it's even that some tribes are subjugating other tribes in our national systems. It's also an issue of why does the Judicature Act of Kenya and many African countries, or for that matter, other still refer to English common law as a primary reference point rather than our own common laws, which we have developed over the years from customary practices. Those are issues which will become even more difficult with a world constitution. So these are some of the issues that need to be addressed as we move forward. And I've given some examples that, of course, we could use even national constitutions as a basis. We could use regional and sub-regional, and we could use international global instruments. And as I stop, I need to recognize again the contributions that some national constitutions have made towards what we would call a global or world constitution, towards a world global understanding of human rights. Because there are certain things which we must accept are common to all of us. We must accept that. And these are like the Indian constitution, when India got independence, and then the influence of Mahatma Gandhi in terms of his strategy and in terms of his philosophy, etc., the Nehru, etc. India has had a very, very big impact on many constitutions, and particularly in Africa, like constitutionally and in terms of legislation, because a lot of the laws came to Kenya, for example, or many African countries, from England to India, where they were enacted, then to Kenya, because the Englishman believed that you could not easily import English law from the UK to Kenya directly. You needed to, and Africa directly, it had come to India after it had been made more appropriate there. So India has made a big contribution to democracy and development. Then, of course, there was in Africa, there also saw the independence of Ghana and what it meant in 1957, and what its constitution and the Nigerian constitution meant for the development of our constitutions in Africa. Of course, then you had the 1995 Constitution of Uganda, which was very, very progressive at the time, embodying the questions of rights, issues of devolution, etc. Of course, more recently, it has been decentralized. And lastly, of course, then South Africa came, and that was a breath of fresh air, not just in Africa, but in the world, in terms of its constitutional text, but also the question of racial rapprochement, in terms of trying to resolve historical, continuing and resurgent issues of apartheid and discrimination and exploitation. Which then lastly, of course, the newest kid on the block in terms of constitutional debate has been the Kenyan Constitution 2010, probably the most progressive constitution, quite bulky, but of course, there have been challenges with implementation, and there have also been challenges with some issues that we did not understand at the time that we need to think about. The last comment here being that, for instance, we have experimented in Kenya and many African countries with this dichotomy of presidential constitutions and parliament, pure types. Kenya has now realized that at independence, we were going mainly parliamentary with India. Kenya has realized that from 2010, we wanted to go so much into the pure presidential system, which was invented by America. But then between 2008 and 2013, Kenya had an experiment coming out of post-election violence, which was basically a hybrid mixed system which was both presidential and parliamentary, or what you would call a parliamentary leaning hybrid. And it worked reasonably well for this country in terms of the basic problems that afflict Kenyans: tribalism and tribal exclusion, corruption, and a sense of shared prosperity through inclusion, through economic efficiency, etc., etc. And therefore, many Kenyans, including I, believe that a mixed hybrid constitutional structure would be the best for Kenya and many countries, rather than these pure types which have failed our countries and even which are not working in where they were invented. The pure parliamentary system is not working for Britain. The pure presidential system is not working for the US. And they are saying it themselves. They are scholars, they are statesmen, and stateswomen, that their leaders are saying this. So as we move forward, let us reconsider the questions of, do we want complete unity, or is it unity in diversity, and allow that diversity, reasonable diversity, while we also like the idea of unity, and that the world constitution is under debate that, in my view, that for now should focus on us implementing what we have at sub-national national level and improving it, implementing and improving what we have at regional level, and improving and implementing what we have at international level, with, of course, some room to think about a world constitution, but not exclusively as the main project that would occupy all academics all the time, without those other nuances and those other questions of diversity. I thank you very much for this great opportunity to address us. Thank you.
Thank you so much for such an interesting, enlightening, and enriching address, Professor Sihnaya. Ladies and gentlemen, it is now time for the paper presentations. As stated yesterday, the general rules of the presentations are as follows. There will be 4 paper presenters this session. Each presenter will get a total of 10 minutes to present their papers. Each presenter will have to mandatorily finish their presentation in 7 minutes, and the remaining 3 minutes will be reserved for question and answers. Each presentation will be strictly timed by the moderators, and adequate warnings will be given to the presenters. And the presenters are requested to keep an eye out for the chat box for the timing warning. So with this, let us commence. Our first presenter is Ms. Samruddhi Mahadgot, Assistant Professor of Law at Victor Dantas Law College, Kudal. Ms. Mahadgot will be presenting on the topic Problems and Challenges on Enforcement of the World Constitutions.
Hello, am I audible?
Yes, ma'am.
Okay. My topic for today's presentation is Problems and Challenges on the Enforcement of the World Constitution. The 2 world wars had already destroyed the manpower and the property of the world, and the various nations had divided themselves into 2 blocks, and they were planning to wage a 3rd world war. If the 3rd world war had occurred, the entire world would have been destroyed. There were also caste-based, sex-based, religion-based, and race-based discriminations. Inequality between the man and the woman, and atrocities of the Nazis on the Jews. There were mass killings. The 2 world wars had already destroyed the manpower, and somewhere all these things had to be stopped. So the United Nations organization was started by 51 nations who came together to form the United Nations organization, and it is an organization that aims at maintaining international peace and security, develop friendly relation among the nations, achieve international cooperation, and it is a center for harmonizing actions of the nations. So it has established the Universal Declaration of the Human Rights. It has developed the UN Charter, which has granted various human rights to the people of the world. Various committees and the commissions, the main organs and the subsidiary organs of the United Nations organization are striving hard to protect the human rights. We can consider human rights as those fundamental, inalienable, or the natural rights which are essential for us to live as a human beings. And without these rights, we cannot exist properly. They are essential for our growth and development and progress. So, influenced by this Universal Declaration of the Human Rights and the UN Charter, the Indian government had adopted these rights in the Indian Constitution under Part 3 of the Indian Constitution that deals with the fundamental rights. These rights were made enforceable under Article 32 and 226 of the Constitution. And after that, we also enacted the Protection of the Human Rights Act in the year 1993. We developed two commissions, the National Human Rights Commissions and the State Human Rights Commission for the enforcement of the human rights in India. But these two commissions were given power to only investigate and inquire into the violations of the human rights. And they were supposed to report to the central government and the state government regarding the violations of the human rights and regarding the protection of the human rights. But we see that there are flagrant violations of the human rights even today. Use of the biological weapons to kill the civilians, which violates the principles of the humanitarian law, the cross-boundary terrorism, trafficking in human beings. There are various examples of the violations of the human rights, the bonded child labor system, slavery, slave trade. All these are examples of the flagrant violations of the human rights. Therefore, the important question that is raised today is whether we have to draft the world constitution to protect the human rights. In my opinion, there are practical difficulties in the drafting of the world constitution. If we compare the national law and the international law, the national law tends to be stronger than the international law. International law is very weak. At the national law, we have legislature to draft the laws, we have executive to execute the laws, we have judiciary to enforce and implement the laws. There are law commissions which will suggest amendments to be made to this laws which are drafted by the legislature. And there is a police authority which will assist the two commissions to investigate and inquire into the violations of the human rights. But at the national level, we do not have a world legislature to draft the world constitution. We do not have world executive to execute the provisions of the world constitution, and we have the world court. There is a world judiciary, but there is a problem of the jurisdiction there. The International Court of Justice will get jurisdiction only when the two disputing states are going to grant jurisdiction to the International Court of Justice, and the decisions of the International Court of Justice are binding only on the parties to the dispute. So the International Court of Justice will not be in a position to enforce and implement the provisions of the world constitution. Again, even if we draft the world constitution to investigate into the problems of the violations of the human rights, there is no police authority at the world level. There are no law commissions at the world level to suggest changes or the amendments to be made to the world constitution. And the law will be not a progressive law. It will not be able to cater to the changing needs of the society. There is also no World Investigation Bureau to investigate into the violations of the human rights at the world level. So in the absence of these mechanisms, I think the framing, the drafting and the enforcement of the world constitution is a difficult task. Again, if we draft the world constitution, there is a problem of the prevalence of the law. If there is a conflict between the constitutional legislation at national level and conflict between the provisions of the world constitution, the which law should prevail in that case. And again, the nations are not going to be ready to give up their sovereignty and be willing to draft that world constitution unitedly, because we have a multipolar system today. Each country wants to become a superpower, each country wants a sovereignty, and therefore they're not going to come together to frame a world constitution, because each country has different political principles. And I think time is not right for the drafting of the world constitution. We have to focus only on implementing the provisions which have already enacted at the national level and the international level. I have completed my presentation, and thank you. Thank you for giving me opportunity to present this paper.
Thank you, ma'am. The question time has now started. You have 3 minutes.
Yes, sir.
If anyone has any questions, they may ask either in the chat box. If you have a question, please type it in the chat box. Ma'am, there is a question. In light of the Gambia versus Myanmar case, what do you think? Should the rule of locus standi be relaxed in the ICJ cases?
In the International Court of Justice, there is no question of relaxing the normal rules. There is no question of a locus standi. Only the states can be the parties to litigation.
Ma'am, your second question is whether the existing mechanism of human rights enforcement is sufficient in future and can be adopted as it is in the World Constitution.
Even at the national level, I think we need amendments in the laws that we have. As I've already said, the State Commission, Human Rights Commission, and the National Human Rights Commission we have, but they have not been given powers to act on the violations of the human rights. They are like tigers without teeth. Only investigation and inquiry can be conducted by them. So we need amendment here in this national legislation also. We need to give them more powers so that they can take some action on the violation of the human rights. Any other question?
If anyone has any question, yes. There's a question, why should we think existing institutionalized system for enforcement? Can't we make institutions to be part or supplemental part of the World Constitution? Is it not merely a showstopper?
I think the nations are not going to be ready to unitedly frame the world constitution, because each country has different principles. See, even if we take the example of giving religious rights to the people, which we also consider as one of the part of the human right, there are some countries which are secular in nature. There are some countries which impose state religion. There are some countries which want to be democratic in nature. Some countries still believe in the terrorism. So I don't think nations are going to come together to frame the world constitution. They are not going to give up their principles of nation, which they have developed themselves. Again, they would be not ready to give up their sovereignty.
Thank you, ma'am. The question time is up. We will now move on to our next presenter. Our next presenter is Dr. Madhura Karamkar, Principal in charge of HVPS College of Law, Mumbai. Dr. Karamkar will be presenting on the topic Constitutional Law, Current Trends and Challenges.
Am I audible?
Yes, ma'am.
Okay, thank you. So good morning, everyone.
You may start.
I'm very much thankful to the JLC College for giving me an opportunity for presenting my topic on constitutional law, current trends and challenges. I'm also thankful to the principal ma'am and the organizing committee for their constant support. And I wish all of you a very happy new year and a healthy life. So now I'll start with my topic. Next slide, please. Yeah. So it is very well said by Jean-Jacques Rousseau. The state owes its authority to the general will of the governed. The nation itself is sovereign, and the law is none other than the will of the people as a whole. So here, if a society has to be formed, the state must be established for it. And once the state is established, then there is no other way for its order, but obviously it is a constitution. So our sculpture of the Indian Constitution, Dr. Babasaheb Ambedkar, gifted the Indian Constitution to our people of India to make them aware of their rights and duties, is based on the principle of equality. The development of the Indian way of life is possible only when the people of our country, they will not deprive of their necessities of life, and for that the laws need to be tightened to strengthen the three objectives of population control, compulsory education, and preservation of morality. And for that, everyone needs compulsory education. So here now the role of government comes, that the government has enacted ministerial and amended laws for the protection of women and child development. However, law enforcers are endangering the safety of the woman by engaging in custodial violence and misuse and abuse of power. The thought-provoking question here is how safe our children are in the hands of those who have a responsibility to support, improve, and rehabilitate orphaned and exploited children. Yeah, next slide, please. So, A.V. Dicey also says about the Constitution that there is no constitution or law in Great Britain. So, England, here my question is to be or not to be. So, England does not have their written constitution. However, still it has followed the principle of constitutionalism. A country may have a written constitution, but still lack in the spirit of constitutionalism. Whereas a country may not have a written constitution, but uphold and full effect to the spirit of constitutionalism. So the inducing question here is to have a constitution, but no constitutionalism, or to not have any written document of constitution, but still adhere to the principle of constitutionalism. Yes, next slide, please. So now speaking about the current trends and in the world constitution, great philosopher Aristotle says about the doctrine of separation power, when he introduced that the government should be divided into three different branches, but he did not specify their separation. Montesquieu, the French philosopher, in his Tres Politica, he viewed that without the check, power must never be trusted. Therefore, he divided government responsibilities into three different categories of the legislative, executives, and judicial. And he sketched out how liberty is affected if these powers are vested upon the same person, which leads to tyranny. Now, according to the Ved and Phillips, they also have highlighted on the separation of powers into three different things, that there should be an independence of one organ of the government, that it should not control or interfere with the exercise of its function or another organ, and the same person should not form part of more than one organ. So there should be separate and distinct individuals in all these three branches. The function assigned to one organ should not be exercised by the other organs of the government. Yes, next slide. Now, here I wanted to point out about the rule of law, which is derived from the French, which means the principle of legality, and which is opposed to arbitrary powers. Thomas Fuller, in his words, he said that be a neighbor so high, the law is above you. So no one is above the law. Therefore, the weak will be stronger than the strong, and justice will prevail. Thus, in ancient times, we see when the rulers were the kings, the concept of law was created to control the use of their arbitrary powers. And in a democracy, public rights holders must explicitly prove that the exercise of power is legally valid and socially justified. Yes, next slide, please. So here I am trying to show the comparative analysis of the Indian Constitution, as while drafting our Constitution, Dr. Babasaheb Ambedkar, who headed the drafting committee, and J.B. Kriplani, who is the head of the Fundamental Rights Subcommittee, they have taken the reference from the English Bill of Rights, French Declaration of Rights of Man, and the United States Bill of Rights, UDHR. And by considering this, the needs of the people during the tough time of partition, and were incorporated in our Part 3 of the Constitution, which is described in Magna Carta of the Constitution. For our constitution makers adopted the provisions from the Government of India Act, Federal Scheme, Emergency Provisions, Public Service Commission Act, then Officers of the Governor, Judiciary, and Administrative Details. So from Constitution of US, we have borrowed the preamble, fundamental rights, federal structure of the government, electoral independence of the judiciary, separation of powers. From British Constitution, we have taken the parliamentary form of government. So the idea of single citizenship and the rule of law reads. So these we have taken from the British Constitution, and from the Canadian Constitution, we have taken a quasi-federal form of government. From the Irish Constitution, we have accepted the directive principles of the state policy. Then from the Australia Constitution of the Australia, we have taken the freedom of trade and commerce within the country and between the states. From French Constitution, we have taken republic and the ideals of liberty, equality, and fraternity in the preamble. From Constitution of South Africa, we have taken procedure for amendment. From the Constitution of USSR, we have taken the fundamental duties under Article 51A. And from the Constitution of Germany, we have taken emergency powers enjoyed by the Union. From the Constitution of Japan, we have taken the procedure established by law. My time's up, or still time is there?
Yes, ma'am. The time has concluded.
So can I conclude?
Yes, ma'am.
Yeah. Yeah. So here I just wanted to conclude with this, with the statement given by the Nelson Mandela: to deny people their human rights is to challenge their very humanity. So there are many issues and challenges which I have already submitted in the paper, but due to the lack of time, I can conclude my topic over here, that special attention needs to be paid to the public health, education, transportation, water supply, sanitation, women's safety, and the gap between rich and poor, developed and underdeveloped, which is very widening, and the social issues that arise need to be seriously considered. Big problem for the citizen is to get their constitution all rights on an equal footage. So our government has often failed to provide equal rights to citizen, be it property or their right to return or full political participation. So it is necessary to analyze some of the important concepts that our country has borrowed from various countries by and adopted by our constitution makers, and many colonial laws which were accepted verbatim. Therefore, if the violence persists in the society, we may not be able to achieve the goal, but we must constantly strive for control. The sooner we come together, the goal of building a non-violent society, the sooner we'll be able to develop our country and the world constitution. So in this way, I am concluding my topic.
Thank you, ma'am. We will take two questions if anyone has any questions. Yes, ma'am. The first question is, as stated by you, Britain abides to constitutionalism to a greater extent whilst not having a written constitution. Does it have to do with the effective implementation rather than the formulation of new laws?
1 minute. Britain abides to constitution rather than the formulation of new laws. There will be no problem in formulation of the new laws, as we have the written constitutional, and there is a difference between constitution and constitutionalism. Our constitution is a written, and constitutionalism is not written, but for the formulation of the new laws. But obviously there are through the amendment, if it is the goal is for the betterment for the society, but obviously the new laws can be formulated.
Ma'am, I think the question time is up now. We will move on to our next presenter. Our next presenter is Professor Mohammad Sahib Hussain, a professor of law at Kampala International University School of Law, Kampala, Uganda. Dr. Hussain will be presenting on the topic Problems and Challenges on Enforcement of World Constitution.
Yes, I unmuted. Yeah, are you hearing me?
Yes, Doctor.
Yes, yes. Before I could start it, I would thanks to the people, those who are given the chance that I mentioned in my slide, Organizing Secretary Asmita Vaidya, Principal, and Convener Mrs. Sheikh Nusrat Afroz, Co-Convener Kritika Temburnikar, if I may be wrong in my pronunciation. And today the keynote speaker, Ben Sihnaya, has widely covered the things, and I will first and foremost congratulate him for that good session that he did. Yes, next slide, sir. Yes, in this 3 days international conference, you know it that I am going to make it out next time. The same thing which I repeated. Then I put it in the 6 forms. That's the introduction, background of the World Constitution, problems in the World Constitution, challenges faced with the World Constitution builder, conclusion, and recommendation. In my yes, keep it there. No. Yeah. In my beginning, yes, introduction. Yes, you can keep it. Turn to the introduction. Turn to the introduction. Yes. In that introduction, I said in my work also, I started with the 3 letters. That is the first person singular plural and the definite article, then the people. It is nothing but we the people. And if you happen to see my full-length paper also, I also ended with the we the people of one of the saying of the person by name that I put it over there. So what I want to say is the concept which has come over there is not only the UN Charter, but we do have the Vasudhaiva Kutumbakam, which is already there in the Upanishad. From there we started. So next. Yeah, if you see the background of the word that I just before in the first slide I made it the acronym VK, there is a Vasudhaiva Kutumbakam. The word is one entire family from there. It has come out the Maha Upanishad. We want to make it as on one platform we would like to make the world, all the nations. So the world Constitution consists of the fraternity, tolerance, compassion, solidarity, and the last but not least, the rights and duties, including the human rights. Yes, next slide. Yeah, problems in the world constitution, Ben Sihnaya has made it very much clear that what are the problems would be there, challenges would be there, but there are many other things that I could not concentrate on the exhaustive list. But here I mentioned the diversified culture, different dialects, the speaking, different faith and religion, individual rights, protection of property, different legal system like the civil law system and the common law system, and the state sovereignty and the dilution that I made it very much clear in the full-length paper, and the forms of the government, because there is the parliamentary form of the government, is the president form of the government, and the minorities production will be there in India in the same way whether the world constitution will be there. There's a problem where the protection will be given to the minorities or not. Then unawareness because of the lack of education, because India also will have the less people are educated over there. And the irrational religious beliefs also there, like ideals, humans, good humans, bad humans, and the slogans of the world constitution, it will take its own time to bring them nation. No one platform, which is the time consuming factor, but not impossible to make the common or irrational slogan. Yes, next. And when the problem would be there, yes, problem that we narrated, but how do you overcome the challenges faced by the world constitution builders? So the challenges, the interpretation of the constitution, judiciary, as earlier our presenter said, the separation of the powers, and also they made the rule of law also there, the balance between the fundamental rights and the principles. And yesterday session also they made the direct principle of state policy, even that also a problem, challenges, stability of the government, relations among the one state and other states or the countries, and also include the internal emergency. To name of the few I discussed below, there is a peace building work and a mass violation of the human rights, try to reduce the corruption, abuse of the power of the building for more accountable government, to constitute a conditional president to minimize the state fragility, different understanding how it sides to some of the good practices in the situations. So these are the challenges that we have it, but I very clearly I mentioned the challenges in detail in my excellent paper. Next. Yes, in the conclusion that I would like to make, World Constitution may not settle every material issue, problem, or challenges. The World Constitution is a political process that is vulnerable to prevailing circumstances. In getting started, the World Constitutional practitioner must anticipate the number of challenges which can take the multiple forms. Then finally, the World Constitution builders may need to manage expectations, particularly of the marginalized and minorities, while attaining their support may require the expanding official safety nets, drawing them into the mainstream may take them. So the author is having the view that is trying to research about mentioned issues to understand the things. Yes, because I want to say that because most of the next conclusion, the recommendations. Yeah, these are the recommendations which I made it over there. The author is having the opinion of the discussing the problems, challenges, and then first from the World Constitution made the following recommendations which are enumerated below. Identify whether the particular constitutional solutions that may succeed in preventing the stopping the violence also effectively address other constitutional issues of individual liberty, faith, speech, and expectation and the state of sovereignty and its function, practices. Yes, 2 minutes left over there. I saw the things. The world is changing. Then you can see that what I posted on the screen and everybody could read. And the oldest written constitution, then the saying that the word, the three words that we and we the people, and here the words citing the quotation, the root better, Ginsberg quotations I said everything with that. So it is open to the floor. Yes, back to the anchor.
Thank you so much, Dr. Hussain. The floor is now open for question and answers. If anyone has any questions to ask Dr. Hussain, they may please post it on the chat box.
There are two possibilities are there, whether they understood fully or they did not understand anything. Probabilities. Yes, is there any drafting committee of the, which is the most detrimental challenge of the world constitution? Yeah, it is not only one aspect, there are 360-degree aspects of to be there when the matter comes to the enforcement is concerned. Because now you take the Dowry Prohibition Act is there. Do you think the people are not taking the dowry? And recently the judgment has given the Supreme Court stating that, what do they say? Merely wanting the dowry is not the offense. The conviction will be given by the Haryana court. Now they acquitted it because merely saying it goes with the, again the cruelty would be there. So what I want to say is merely keeping the world constitution is a draft is not immoral, because its effectiveness also will be very much important factor than how it could be enforced. That is a challenge with the issue. Yes. Yeah, drafting community means, yeah, community, everybody would be there. Like the Indian Constitution drafted with the many people where the father of the Constitution, B.R. Ambedkar, is there. So in that way also, the people from the various respective states will make the representation would be there. Then they will sit and then they will draft the Constitution. World Constitution will be there. Okay, next.
If anyone has any question, please post it on the chat box.
Okay, shall I close? Shall I quit?
Sir, there is one more question. What are
some main subjects that should be included in the making the world constitution? See, I told you, the Indian constitution made from the various other constitution, just one of the presenters made it from the various countries' constitution that we make it out. Because there is a saying would be there, if the first man will fast, the next person who follows it, he will be alert. So now we will see what are the defects would be there in the entire constitution in the world. Then we will take it and see that it will be harmonized and and everybody would be happy. Of course, we cannot make everybody happy, but we can harmonize them at least to a certain extent. By taking the good thing from the various other countries and include it, and that we make. And we don't think that we are making cutting and pasting over there. It is a box of all the cutting and pasting, but we make it useful for the especially to the every country would be there. That will also take into consideration when you are making and implementing the things. Next. Various states can base their new provisions or amendments. What are the time being the various states can base their own? Yeah. See, like the Indian Constitution, they made 103 times amendments would be there. Whereas when you come to the USA Constitution, you know the figure. So generally, whenever the loopholes are made, then the amendment should come. And moreover, the amendment comes at that instance only when the society faced with the Constitution should having the pace with the society. That's why amendments are needed. Next.
We may take
So,
one question.
Yes.
If someone has any question, please post it on the chat box.
So I should say that thank you very much for giving the chance for this slot to express my views and opinion.
Thank you, Dr. Hussain. I think we can close it now. We'll
Thank you
move
very
on to
much.
the
Thank
next.
you very much.
Thank you,
Yes.
Dr. Hussain.
Yes,
We'll now
yeah.
the next presenter.
Yes, yes.
Our final presenter for this session is Dr. Sajid Patel, Assistant Professor of Mercantile Law at DAV Velankar College of Commerce, Solapur. Dr. Patel will be presenting on the topic World Constitution as a replica of Indian Constitution.
Good morning, one and all. Sir, I am audible.
Yes, sir.
Myself is Sajid Patel. I am working as Assistant Professor in Mercantile Law at DAV Velankar College of Commerce, Solapur. And my topic is World Constitution as a replica of Indian Constitution. Now, as we consider, as globe is an international community, like any other community, there are various members having different traits, backgrounds, and needs, and so it becomes necessary to make a proper concrete law which will guide and govern them so that international peace and order may be maintained and frequent violation of human rights at international level can be prevented while making world constitution. I think some of participants have stated that uh, it is very problematic to draft the world constitution and there are some challenges and problems while drafting the constitution. Yes, it is very difficult task to draft a constitution, but uh, when all the members of a global community they decide that a world constitution is to be drafted with the spirit with which they have drafted United Nations Charter, they have established United Nations Organization. With that spirit, I think it would not be impossible to draft a world constitution. Of course, it would have its own advantages, it have its own disadvantages. Now, there are always international instruments, international documents, protocols, they are made under the title of international law, like Universal Declaration of Rights is there, uh, CEDAW is there. Again, there are various international instruments dealing with uh, specific matters, but the problem is not solved, and violation of human rights has not been discontinued; it is continued. Now, why United Nations organization was established as as a result of failure of League of Nations and massive violation of human rights due to Second World War. United Nations organization was established. United Nations organization is working through organs like General Assembly, Security Council, and Secretariat. Security Council works as implementing or executive authority of United Nations organizations. Now, it is a need of the document to be called as the World Constitution. Now, if world constitution, if at all it is to be drafted, it is to be made, in my opinion, the provisions of Indian constitution, they are relevant. Why? Because Indian constitution is one of the best constitutions in the world, and the constitution was drafted while after referring the provisions of other constitutions. So it is masterpiece. Now, some international documents, they do provide these provisions which we can see in Indian constitution. And I think that there are some noble provisions which are there in Indian constitution. They can be borrowed while making the world constitution. Like uh, we have preamble of the Indian constitution, uh, which which gives the idea about the intention of the framers of the constitution, why framers of constitution have enacted the Indian constitution, which start with the word we the people of India. So it would be possible that uh, world constitution would open with a word that we the people of the world, and may end with the word do hereby adopt, enact, and give ourselves to this constitution. Like there are certain words which have very important meaning, like socialistic, secularism, democracy, democratic, social, economic, political justice, social justice, liberty of thought expression, belief, worship. These words have very huge meaning, and in my opinion, they can be borrowed while drafting the preamble of the world constitution. Now, next, I think that the most important part of Indian constitution, that is the part 3 of Indian constitution, that is from articles 12 to 35, it deals with fundamental rights, uh, that is fundamental right to equality, fundamental right to freedom, right to life, right against exploitation, right to religion, cultural and educational rights of minority, right to constitutional remedies. All such rights may be guaranteed under the constitution, and these rights should be given to each and uh, every citizen of all the, what you can say, all the members of global community. Now, uh, again, next part of Indian constitution, it deals with the direct principles of the state policy, comprising from articles 36 to 51. These are the welfare provisions for Indian people. Now, I know it is not possible to satisfy each and every need of all the individuals across the globe, but as far as possible, these provisions also can be borrowed. And for the welfare of citizen, their states may be held responsible. And there is a problem, I think, in implementation and enforcement of these provisions of world constitution. Now, the role which is played by Supreme Court of India in case of enforcement, in case of implementation, adjudication of matters relating to violation of constitutional provisions and human rights, the role may be played by the International Court of Justice. For that purpose, it is necessary that some organized provisions, some concrete provisions should be made. Already there are provisions, but these provisions are scattered here and there. So uh, it is possible to have the document under the name that is a World Constitution, and which may be uh, implemented by the International Court of Justice with the help of organ of Security Council. So this is about my presentation.
Okay,
Yes.
thank you. So we will now have questions for Dr. Patel. If anyone has any questions, please post the question in the chat box. So you have a question. How do you think nations will be able to look over the differences and make amends to the national laws and beliefs for the greater good?
How do you think? Yes, as I already told that organized law is necessary, organized authorities should be created. All these aspects I have dealt with in my paper, that as we have legislature, executive and judiciary, it is also possible to have legislature, executive authority in the form of Security Council, and judiciary is already there, International Court of Justice. So that so far as that legislature at international level is concerned, members would be representative of each and every country, and they will look over the matter.
Sir, you have another question.
Yes.
Where will the sovereignty lie under the world constitution? Can it be as it is in India?
Sovereignty is already given to all the state. As I've told that it is global community. Each and every member of community have already sovereignty, and they would have come to together to form this document.
Sir, another question. How can
Yes.
ICJ take the role like Honorable Supreme Court of India when there are so many jurisdictional challenges and when decisions of ICJ would be binding only on state parties?
Yes, yes. For that purpose, provisions can be made in the world constitution. Like there are provisions in our Indian constitution regarding the jurisdiction, which matters can be entertained by a Supreme Court. Likewise, provisions can be added in a world constitution so that International Court of Justice would be governed by proper rules.
Thank you, Dr. Patel. The question time is up.
Okay, thank you very much, sir.
A big thank you to all participants for such informative paper presentations. I would now like to take this opportunity to introduce our chairperson for this session, Dr. Ushoshi Guha. Dr. Guha is an IPR attorney who retired as the principal of PG College of Education. Dr. Guha is currently the managing partner at Lex Regia LLP, a firm specializing in intellectual property laws, and is also a secretary of the Samvedana NGO for protection of human rights of senior citizens, and an executive member of Santulan LLP, specializing in alternative dispute resolution. Dr. Guha specializes in patents, copyrights, trademarks, designs, GI, and related prosecution, and provides consultancy in skill development, incubation, and innovation. She is also a WIPO certified arbitrator and mediator, and an executive in the Indian chapter of the World Constitution and Parliament Association. Without much ado, I call upon Dr. Guha to kindly address the conference.
Thank you very much. I get how much time? 5 minutes, 7 minutes? Yes. I get how much time to talk? 5 minutes, 7 minutes?
You can take 10 minutes.
10 minutes, madam.
10 minutes. Thank you very much. I don't need 10 minutes because everybody has spoken so well. With all my respectful salutes to Government Law College, Dr. Asmita Vaidya in particular, all the learned professors, coordinators, speakers, and everybody in World Constitution, that is WCPA. And it has started with a very good note from Dr. Asmita Vaidya and Dr. Professor Glenn Martin. Glenn Martin, who has been always a supporter and who shares a lion's share in writing the World Constitution, he had been continuously talking to us, and Dr. Vaidya had always been in our core group in discussions. We have received such important inputs from Dr. Asmita Vaidya. So congratulations, Government Law College, for having such a global personality as head of the institution. So your what do I say? Your team happens to be so well versed with everything that it would take time for me to praise everybody. But all praises, all superlative words to everybody from Nuzhat Afroche to Tembulnikar Madam, to Anirudh, to everybody. To start with my contention, I'll just take 5 minutes. It would be just a summary of what all have been said. I'm coming to Professor Ben. Professor Ben has suggested some very good points, and that, of course, everybody knows. But then the implementation part that Professor Ben has emphasized, that there is a difference from how our world constitution is different from UN Charter. Let us try to segregate it very microscopically. Let us analyze it. Let us analyze the constitution of democracy, that is on the first higher level. Then what can go to referendum? That is one of the homeworks. Of course, Professor Hussain has mentioned few points about it. So I am coming to Professor Hussain's summing up also. At the same time, allow me to mention the constitution of Kenya, that hybrid constitution system, the framework. So see, what I want to mean, that world constitution has been prepared. It is just a white, not even a white paper. This will go under so many changes. It has to go through changes. And the changes in which directions? The changes in the direction of, if I can mention, that can we have a scope or flexibility for a hybrid system. All countries cannot have the same ad verbatim constitution. If it is written, that can be like that can have directive principles. About directive principles also, somebody mentioned very well. I'm coming to that. This is one part that I want the whole house to appreciate. Number two, the whole house has to think about immediate implementation strategies. Policies are made that would go under something, but the strategies for implementation. And for that, we have to take into account the few of the things that have been taken into account: the doctrine of fundamental will, natural rights, decolonization, and all these doctrines can take care in our world constitution. What I'm trying to impose upon, or what I'm trying to express very sincerely, that the world constitution has to undergo change. Change means not drastic change, but here and there can be substitutions for flexibility. Number two, what I am really concerned about, and which came out of the technical section too very well, and every presenter expressed that implementation, ad verbatim, whatever world constitution is existing today, cannot be implemented today. For the constitution, various countries have to be involved also. At the same time, amendments, there should be a scope for amendment, and amendments should be made. And like as Professor Samruddhi said, no powers to take action. Okay, implementation is not so easy, and many countries will be unable to give up their own strategies or their cultural roots. That is basically causing points or factors for war. So, like Samruddhi Madam said, it is not easy, but this is a forum which will think about what should be implemented such that the countries can accept it. How United Nations strived after Second World War, every one of us mentioned. But on the similar lines, it is going to be a Herculean work, but the work has started with everybody's efforts. The World Constitution must have provisions of flexibility also, and such provisions have to be given such that unwilling countries also with some changes, may come to a common consensus that we want to refrain from war, without mentioning name of any of the peaceful thinkers, because that has been mentioned so many times. But thinkers from time and again have been talking about world peace, and we want world peace. That is the one common good. Dr. Madras stressed upon with new laws. Okay, new laws. And then the urge for striving for controlling the factors that have been responsible for waging war. I remember one thing, Professor Ben has been talking indirectly about it, but then as Professor Hussain also has, actually the war is waged in the mind of people, not on the war field. So let us first of all prepare our minds. And who is going to prepare? It is not we, the people, the Constitution. So, like Professor Ben said, that the cultural diversity is there, but then cultural issues must comprise of a part of education. I am a great proponent of education. So in the schools, in the colleges, the education for peace, like there is something known as human rights education, right from the beginning. Let us educate our children. In every country, there should be an element of human rights education and peace education, such that the riots and the war is not waged in the minds of the children, then youngsters, and then practically waging a big war. That is one small little point I wanted to put into. Of course, World Constitution directly cannot put it, but World Constitution can indirectly ask for having human rights education, because our policies should have all these things in the, like Indian Constitution has equality, fundamental rights, right to education, right to life. All such things specifically can be included in the World Constitution, which of course indirectly it has the World Constitution, because I am a WCPA person. Continuously we have been talking about, and this forum, whatever the resolution outcomes they come, that would be received very well, very well by Glenn Martin, and it would be seen that it is incorporated in a proper manner in the World Constitution. I am coming to whatever Dr. Sajid, Professor Sajid also said. Professor Sajid talked about adjudication of matter, and Professor Sajid has been asked a question in which he answered that International Court of Justice has to understand, International Court of Justice has to understand about the jurisdiction parts. Yes, jurisdiction has also been talked about by Professor Samruddhi and by other professors also. So International Court of Justice, this part also has to be elaborated very well, such that jurisdictional problems do not arise to that extent. So all the legal luminaries and all the government and all those who are connected to the subject of Government Law College and of India and across the globe, I have two small, what do I say, contentions or opinions. One is implementation of human rights education, human rights and peace education. It can be human rights and duties, peace education, some way or the other. Like every country has their national policy of education. Similarly, India has come to a stage when national policy of education 2020 and 2021 has been framed, and it will be implemented now in 22, where it is specifically written that right from the childhood, the children should be given the education of human rights, duties, and peace education. Whether based on their own cultural, what do I say, own cultural materials that are existing with the country itself. Because India or Bharat has a very rich heritage. Similarly, Africa, or everybody has a cultural heritage. And then the educational material should be written in such a manner that right from the beginning, schools and colleges, it will be given not only as moral values, but also as education for human rights, for peace, human rights for global thinking, for thinking in the form of global community. My friends, I want to emphasize this point, that we are yet to think about global community. We may be talking in a forum, but how about the citizens at large? Are they thinking about only their community or only in terms of their country? Are they thinking that there is a global community? Many segregate the two different concepts, that there is nothing known as community, global community. This is my country. So let us train the minds of everybody, and that is a Herculean work. And I know Professor Wayne would say, Madam, is that possible? But then, can there be a majority chunk of educated community